over the weekend, when the International Criminal Court, according to him, was save Ghana $400,000 as in judgment debt filed by company Yefre Omo Mishaleti Company Limited. Yacha the lawyer Attorney General or Yene Juma gidi. A year ago for your badamena and the lives of Sami Jemfi, Eduzita Makulu, Abraham Abaleba, Wakamanwa Tumwa, and they no longer debate on the Jakpa and Ato forcing case. And Omujina turn our attention to Senate saga back in Okujeto Ablakwa because Wakamanwa Tum Prekupe. Now, we want to the International Criminal Court, Court 3, in charge of International Chamber of Commerce and Arbitration. Oma dismissing an international arbitration instituted by Mishaleti Company Limited against the government of Ghana. Omo file a case May 17th, 2023. No more claim damages of some $400,000. Apart from that, company no claim say accrued interest at the current Bank of Ghana forex rate, ebesan the 3% account $400,000 in home, starting from February 2009 till now. To yes, calculation of 3% of $400,000 starting from February 2009 to data says kanokano bro the $400,000. This is the total sum. Mishaleti Company Limited na omope edia free o my Ghana ho. Na ohwe case nemu ya, the international arbitration was instituted at the backdrop of an alleged breach of contract related to the rehabilitation of the Ohinijan Sports Stadium in Accra for the hosting of Ghana's 2008 African Cup of Nations. Entinya na semo some of the International Criminal Court say ye nima womo na womo Ghana katwitwe ni say omo woni a contract to rehabilitate Ohinijan Sports Stadium. Yes, I can any friend Accra Sports Stadium. Na Eboama Ghana ya host to the 2008 African Cup of Nations. Now rehabilitation works according to Mishaleti Fui. Na my stadium na baba 40,000 seating capacity with ultra modern facilities in the stadium. Now in 2006, government of Ghana will do those contracts. And apart from Mishaleti, Consa Ghana Limited and so nya contract ni bi ya no mo na rehabilitation works e wo Kumasi Sports Stadium. And afei Waterville and Isophoton Holdings. I'm saying Dean Ringibe. You are the S-While NDC administration to sika puduo de mawomo as judgment debt. Ya no kujeto abla ko wodi mutintimai. Ye ne or ye no holier than thou member of parliament. Entine Waterville, Isophoton, Mishaleti, Consa Ghana Limited. Na rehabilitation works nenya Ohinijan nko say dem sha ceramical na Airwork Sports Stadium eka ho Babayara Sports Stadium that time Kumasi Sports Stadium in Kumasi na nyina aka. Now under the agreement the claimant ye Mishaleti na omo ye local subcontractor na the main contractor Consa Limited for the rehabilitation of Ohinijan. Now on the 1st of August 2007, after the contract has been awarded in 2006, and the government of Ghana terminated the contract with the contractor on the basis say omodo omon krata ebegu Ghana bayanim na Ghana ban ede sankrata ni nyina forward ede ma Ghana mrase bedwa Ghana mrase bedwa hwe omo contract omo krata mu no mu se debi omo nya well equipped to carry out the rehabilitation works ewo do Ohinijan Sports Stadium enti Ghana ban entwa contract because according to the government of Ghana na omo ekra stipulated conditions with which these contractors must meet and sana omonya kwan execute those contracts. Until after some Micheleti for submit documents no cabinet who said they don't meet that criteria. I don't think the contract was terminated on the 1st of August 2007. Now, the value of work undertaken by the contractor was duly certified, and the government of Ghana subsequently paid for all the work certified as has been discharged. Until omo contractors are certified omo dwumade Ghana ban etua omo nyina aka. But omo ntumi meet requirement terminate omo contract na dey terminate omo contract based on the agreement between the government of Ghana and these companies. Until now, bad blood bia any determination. And our motna from 2007 2023 and we dimirika sesa omo krata edeko the International Criminal Court Arbitration Center say arbitration proceedings should be instituted in respect of claims by Omo Micheleti. Say they are part of the contract allegedly was not honored by the government of Ghana. And you know, $400,000 ma womo yewia. Yes, and calculated 3% accrued interest our Bank of Ghana rate from 2009 up to date. The area argument the learned Attorney General Godfrey Yabadame Edebabonte. Now, the learned Attorney General representing the government of Ghana denied liability for any indebtedness and raised a preliminary legal objection in accordance with Article 5, Clause 1 of the International Criminal Court Rules of Arbitration. Assistant State Attorney Annie Marie Ayandru and the Attorney General Godfrey Yabua Dame contended that the claimant had not exhausted the dispute resolution mechanisms procedure applicable under the FIDEC General Conditions of Contract, which required the parties to submit any dispute arising to a dispute adjudication board at first instance, and therefore the tribunal had no jurisdiction to determine the claim by Micheleti. The argument the Kaya Office of the Attorney General Erezi Yene said, 1. O my Ghana yenu biaka. Now we are Article 5 plus 1 of International Criminal Court or one castle rules of arbitration. Ye fiti prekope emfa contract wonsem emfa makot ye won hyehyeye. The dekan say wo dekan e de ye wo dispute resolution mechanism procedure. Ya eno no kire say wo be dekan de asem na kwa koma the dispute adjudication board at the first instance. Now omo dekan hwehwem omo wie na se boro won so a ansa na omo forward e de accord the ICC tribunal kasa ebo omo de asem. But in this case Micheleti Company Limited page asem no a eno omo de koma the ICC tribunal. And after argument number 2 Murezi said, even if the tribunal were to find that it had jurisdiction, the claimant's claim having been filed more than 14 years after the course of action arose was statute barred under Ghanaian law, which is the substantive law of the agreement. And argument number 2, Attorney General Rezi say, Empo said, sa procedure na woso mfom no ma mfom na se tribunal no kura gitum se o tumi so obedi asem no a oba Ghana mramu a case ya edi aburu emfie du 9 ansana ye file case no for an action to arise no Ghana mra no ebra because adsi way back in 2007 2008 2009 na afa na wo file amayaka nwasem a etwemu dadadada. After argument number 3, the Office of the Attorney General assign Erezi and say, the right of the claimant to initiate any dispute resolution mechanism for a matter bordering on breach of contract could only be enforced within a 6-year period after accrual of the course of action which occurred on May 19th, 2009. Into we are by per calculation 6-year period no eba be was a year 2015. But the day you 2024 omo file matter no in 2023. Into that say what did to ho a enye ye de biada. Into the tribunal agreed to bifurcation of issues which allowed a determination of the preliminary objection and the claim of the action being statute barred first. Now, Miss Letty Fono's argument, they say through lawyers also argue, say, or more krata ediama respondent, the government of Ghana, and proposed Jakpa and Ato to settle the dispute within 28 days. But the respondent failed to respond to the notice, hence waived its right to an amicable settlement. And almost this failure by the respondent, it said, gave the claimants the right to file an international arbitration. The claimant further relied on Section 25 of the Alternative Dispute Resolution Act 2010, Act 798 of Ghana, and argued that the respondent did not raise any concern on the dispute resolution mechanism in response to the claimant's letter of March 20th, 2023, and that the respondent acknowledged receipt of the letter. And also argues under Kenyan Arbitration Act, which was the seat of arbitration, the claimant's claim is not time barred. Now here the decision of the tribunal. And the decision of the tribunal, the issue raised by the Attorney General against its jurisdiction to hear the matter. The first ruling on the buyer and say, krasa to me no, so the matter because the claimant had taken steps to notify the respondent of its intention to refer the dispute to a dispute adjudication board before commencing the arbitration proceedings, but such steps were ignored by the respondent. And until a proper say, claimant no edi asem na brɛ omo so to me say ombedi asem, so they upheld some objection raised against the jurisdiction by the respondent. But secondly, the tribunal, however, agreed with the Attorney General of the government of Ghana that the action was statute barred under Ghanaian law, having been instituted way beyond 2014 and 2015. That is more than 6 years allowed by Ghana's Limitation Act. The tribunal therefore dismissed the claims by Micheletti entirely as being inadmissible. The tribunal is currently considering amount of cost to be awarded in favor of the government of Ghana represented by the Attorney General following the dismissal of the claim, and will soon decide and notify the government of Ghana as to the quantum of the amount of cost awarded to them. And the second ruling on tribunal and the by and said the Attorney General can say as somewhere see 2009 about contracting some any resolution of contracting some there. Ghana mrebu say Enfiance yantem and obetumi raise the course of action. Eburu enfiance a atwam. But this is 2009. According to the tribunal, from 2014 na the 2015 and ana Micheletti for no akwenya say omo be raise any course of action on the matter. But won tra no mo amane ya ye what 2024. Now what 2023 too, which is per calculation about 11 years as a saying, and Baby Institute to sorry, about 14 years down the line, and Sana what raise course of action. There be Ghana Mrano Kra Ebra and Nti Omatu case in Atogo. Apart from so Matogo, almost say transfer ye mu echa eka ye damages e dia ba mehletifo no amoma tua dia ma Ghana ban. Na no sa quantum of money e was a mehletifo no tua dia ma Ghana ban as cost. As a result of dismissal of the claim no, so omo transfer na omo eye nhihye wie ni ehunu sika no puduo no a obema Ghana ban aso ate the way any inkunimdia the learned attorney general Godfrey Yabodame akudi the International Criminal Court omaso ya in charge of arbitration against a company ye friend no Micheleti Company Limited the way asset the tone for Nyankopon ya adoma ochina further cross examination ya bekoso the Financial and Economic Crime Division of the Accra High Court emra Ghana ban beto aso across examine the third accused Richard Jakpa led by Director for Public Prosecution ya wojina mudiama the Attorney General Yvonne Atakrobo Bisa. Now a recap of the last court meeting and you me pepe ho na nika na ya rehosem na esan ya sresem. They say principal witness ya ono na dance ye so na court ujina e die twitwaje the first accused case Lato Forcing and the third accused Richard Jakpa your former finance minister said tekpe. The third accused say papa no won ka no kre say ye na asem ya asem oye nipa boni ni o use the word evil esan say contract in komre nyina na wotia wo tia nsem third accused Richard Jakpa ko broso court no bi no ebio osama court nyanti ase say ono document forwarded to my attorney general and attorney general so they prosecute. By attorney general filing the documents on the 16th of February 20 on all the charges 16th of February 2023 over 100 documents no file here. Richard Jakpa forward this document now on Okano Edema the attorney general on the 18th of June 2023. Tina just say some na Okano so na eya tro. Ebi on sabe there they say out of the 68 WhatsApp messages ya ono Jakpa forwarded the command the attorney general. Emi mienu pe and attorney general respond to Jakpa. Emu mienu no mpo no Jakpa de no a woni ade aba court ya wo gina so e de abo attorney general kwan do no ba kokura eni 68 nim. Ebi on sa kopie mo court. Mra Jakpa na kasa to nanum to say or declare war on the attorney general after say attorney general afeli say obeboa no in the submission of no case. Edi nyina so no war na eche say attorney general hye wono Jakpa bo say obeboa no in the submission of no case so a wantumi amfa nyina so bia amfa ama court and a host of other contradicting statements from the third accused Richard Jakpa. Enti konimdie ya attorney general akodi e the International Criminal Court and setting a perfect tone for Nyakopon ya adomo chana. Further cross examination ya bekoso e the Criminal, Financial and Economic Court 2 of the Accra High Court. Yeni be di achiri di ebeto fombia NSMPTV ya de bebre di ebo adame woni mi se wasan akwa win case bi e di ama Ghana International Criminal Court.
Yeah.
Na ehun efori de abai. Enti asamba akopɛ na mi bisa se omo e ka se Godfrey enim judge for Ghana ti no court a wodin kunim no. Apacho International Criminal Court judges nso so onimomo ana.
Na devil because onimomo judges.
No this before say there's one person much say or procure judgment. Ahanti unim judges need to occur. But your International Criminal Court judge for no Godfrey onimomo ana. Ene dia be omoni masoleti for case amodi masoleti for the court International Criminal Court no. O akwa ko Ghana name e di asem ya bom asem na atwatwene. Ama Ghana edin kuni because Ghana lusu sa case na anke betua sika ene de ama wo.
Enti says kana omo kana. Enti said yen.
Omanpanyi call State of the Nation address. Also Kasa Attorney General we. Abua am yesivu some amount
10 trillion Ghana cedis.
Okaya go for say won't be that.
Sika 10 trillion and the other in
Activation case we say Ghana difa. Kebetua. It is Ghana we need to was say we Ghana say ya boss aka.
I plan to dey say nyame ya ya to ano so.
No wa ben.
So Dr. Ba so sa to ano so.
Yeah,
we odame to aso.
Nti say era kanda pa so dimirika akobole. Sanse emebu ni asojafo bi edisi ni wo ho nti wako
I
think any womu a important so yen fanko nti asante yen fa graphic na efa graphic no emra tiabusia ye live on Facebook. So graphic ni or say government releases 47.13 million Ghana cedi for BEC 2024 BEC. Now gonna when an open me can want some say
Kwaku
aban obi release kano aji se wotrase a menkrofo kasa ni betwa BEC mu na fa hin kosi ansa ne release kano e ba sa na fe die